Have our chief judicial analyst, Judge Andrew Napolitano, on the phone. And Judge, I'd like your reaction to the ruling by the Ninth Circuit Court of Appeals upholding the temporary restraining order.
Well, my reaction is similar to what we just heard from Howie, which is that the court, in a very, very narrow ruling, narrow reading of the preconditions for the appeal that the president's lawyers filed, concluded that they're unlikely to prevail on the merits, and therefore there's no reason to live to this day. In my view, they inadequately addressed the primacy of the presidency when it comes to establishing foreign policy, and instead stayed in the weeds on the rules.
Yeah, I wanted to ask you about that. You made a very important point there, Judge, because to continue a temporary restraining order, a court has to say that there is a likelihood that when they actually deal with this on the merits, that in fact they are going to succeed. And when the lower court judge did that, he was saying basically the attorneys general of Washington State and others who were parties to the lawsuit were likely to succeed when it came to the issue of whether or not this this travel ban was legal. And now not only is he saying that they were likely to succeed and therefore he issued the temporary restraining order, but now the Ninth Circuit Court of Appeals is saying that they are likely to succeed on the merits when they get to the underlying issue, which is, of course, the constitutionality of the president's travel ban.
And all of this, Chris, in the face of language which the president read aloud correctly and clearly and word for word in a speech he gave to the National Police Chiefs Association yesterday, which directly authorizes him and every president since Harry Truman to do what he did. So his frustration is palpable. His criticism of the court for dwelling into the weeds and the politics is well grounded. And of course, we're going to be hearing a lot about this. His opportunities now are severely limited. He can ask the Ninth Circuit to sit en banc, which they don't do because there's 29 of them. They sit in panels of 10.
Let me just explain. En banc means that it wouldn't just be the three-judge panel. It would be all the members of the Ninth Circuit Court of Appeals.
Except that this Circuit Court of Appeals is so huge that they don't sit with all 29 members. They sit in groups of 9, 10, and 10. So the three who ruled against him would be joined by another 7, and those 10 would address it anew on its way, presumably, to the Supreme Court. The Justice Department, which finally has an Attorney General, could decide to bypass the en banc request and go direct to what we now know is a hopelessly and equally ideologically divided Supreme Court.